offer?
Yeah, we filed our motion, and with that, we referred to the plaintiff's petition and just the facts of the case, which we believe are sufficient facts based on Chapter 33.004 of the Texas Civil Practice and Remedies Code, with regards to the way this accident happened on Highway 75. The plaintiff alleges in her petition that they were all driving southbound on US Highway 75. Plaintiff was in, as you know, in the front, in the middle vehicle behind the responsible third party, Kerry Foshee, and my client was behind the plaintiff. The vehicles ahead of Mr. Foshee began stopping. He suddenly stopped his vehicle and then started a chain reaction. And then my client was unable to stop in time and hit the back of the plaintiff, and so on. She ended up being pushed forward into the back of the plaintiff. But that is the basis of our request to have him designated as a responsible third party, is that he started the chain reaction. I know the plaintiff in their response had argued that Mr. Foshee was doing what his responsibilities are under the law. However, in response to that, I'd argue that the same argument that they would make as to my client, that if you're keeping a safe following distance, then there's no need you wouldn't have to suddenly apply your brakes in that manner. It would be a gradual braking or a pumping of the brakes or something to that matter, to that, extent. And so in this case, we believe that Mr. Foshee's conduct can be regarded as negligent conduct and as a failure to use ordinary care in this case, and should be, I think he should be, designated as a responsible third party based on that.
Okay. Your response?
Your Honor, I am reading my petition right now. Nowhere in that petition does it mention anything about Mr. Foshee at all. Certainly doesn't say anything about sudden stops or coming to a stop too quickly, nor is that against the law to come to a sudden stop. If the traffic ahead of you comes to a sudden stop, you are required, if you are following the law and paying attention and following at a safe, sufficient distance, you are required to stop before hitting the people ahead of you. Mr. Foshee did that. Christy Lowry did that. And then along comes Richard Logan at an extremely high rate of speed and hits the back of Christy Lowry, smashes her into Mr. Foshee, who was, again, sitting still for traffic. They haven't even alleged he did anything other than come to a stop. They're claiming disingenuously that my petition mentions him coming to a sudden stop. It doesn't. It just doesn't. That's never been our allegation. The police report says very clearly that my client and Mr. Foshee were stopped for traffic. And this is amazing that counsel takes this position because defendant does not. Defendant admitted at the scene, and I've got the crash report right here. Driver, Unit 1, advised he suddenly realized the vehicles in front of him had slowed and he was unable to brake and stop in time to avoid hitting the rear portion of Unit 2. Unit 2 driver advised she was struck from behind by Unit 1. Unit 3 advised he was struck from behind by Unit 2. We were sitting still in traffic when his client comes along at a high rate of speed, rear ends my client, pushes her into this poor guy up ahead who had nothing to do with this. It's disingenuous to come in here and say that I'm making allegations in my petition that I didn't make to support this theory, I guess, that somehow stopping for traffic and having a person behind you stopping for traffic as well, and then having a third person come along and cream the both of you is somehow the fault of the person up front. It's ludicrous, Your Honor.
Based on that same crash report, my clients stated that that's what happened. Not disingenuous in saying that. I stated what your petition states, that defendant was driving at an unsafe rate of speed and his vehicle collided with the rear plaintiff's vehicle. We're alleging
I
that.
said that about Foshi. I never said that.
No,
about
no, I'm not saying that you said that about Foshi. I'm saying that that's what you alleged, and then we're adding our sufficient facts is the basis of it's a line. We're traveling in a line of vehicles, and my client stated that that's how the accident was caused. The only reason for him to suddenly stop his vehicle is because the vehicles ahead of him suddenly stopped, and so that's sufficient. I think that's sufficient evidence at this point. I mean, that I think through depositions and discovery, it may, come out to be, maybe that's the case or not the case. But I think at this point, where we're at in the case, there's sufficient facts to allege that Mr. Foshi is a responsible third party.
Your Honor, there are a grand total of 3 factors and conditions on this entire crash report. Every one of them is against his client, who is the only person who has any reasonable allegations against that.
Well, from a police officer that wasn't at the scene of the accident and is taking everybody what they're saying. So
I think based on everything I've heard, though, I don't think there's sufficient facts to bring this other party in as a responsible third party. I think that it sounds like the plaintiff did not hit that person first, and so they were traveling at a safe distance, and if they stopped suddenly, slowly, whatever, they did it to avoid whatever's in front of them. And I don't think that any negligence can be imparted upon the third party at this point. So I'm going to deny the motion to add this person as a responsible third party.
Thank you, Your Honor.
Right. Thank you, Ron.
Thank y'all.
Appreciate it. Hey, Brian.
Yes.
I'll call you because we got to talk about that other stuff.
Okay.
You free right now?
Yeah, call me right now.
Okay. Thank you.
See you later.